So thus far we've been talking about instances where we have a signed written contract. But what about those times when we don't have a signed written contract? Those times when it's done verbally, or maybe there's a notice in writing or something written that's given to you but isn't signed. Well, in those instances, the court requires reasonable notice if something's going to be called a term of the contract. What does that require? Well, there's a couple of elements. The first element is you must be notified of the terms before you finalise the contract. You can't have reasonable notice after you've contracted because we've already had the meetings of minds, right? It would be too late. The second thing that we need is it must be reasonably obvious that this is meant to be a term of the contract. And we'll talk a little bit about those two applications as they apply to things like tickets that you buy for a plane or a rock concert or something. But to get us started, let's have a look at some cases that deal with the necessity for the term, for the notice of the term to occur before the contract. So in Ollie and Marlborough Court, we have some guests, the Ollies, staying at the Marlborough Court Hotel. And the Ollies have some valuables, some furs. The wife has a number of fur coats which are worth a lot of money. And they had paid for a week in advance at the hotel. They'd also signed the register, so they'd signed in. So really what that's saying is we've had a contract form. After they sign the register and enter the contract, we find that they go to the room where Marlborough Court has this notice. The provider should not hold themselves responsible for articles lost or stolen unless handed to the manageress. Now the Ollies didn't give the furs to the manageress, and we actually had our maid left the door unlocked in the Ollie's room after cleaning it, and the furs were stolen. So they've lost the furs. And so we end up in this situation where the Ollies are trying to get damages for the furs being stolen due to the negligence of Marlborough Court. And what did the court actually say in this instance that's relevant for us? Well, they said that this notice occurred after the contract. Okay, so the notice occurred after the contract, and as such, it was not a term, right? Because it wasn't part of the meeting of minds. They weren't aware of it. They weren't made aware of the term of the contract, which meant that we hadn't given reasonable notice. Thornton and Shoe Lane parking is a similar case where a person had entered a parking station, so they'd gone in, and then once they took the ticket, there was something saying, look, the terms and conditions are over here on a wall, go over and have a look. Basically said where they could go to see those terms and conditions. And they excluded the car park company from liability due to accidents, etc. There was an accident, and so did this disclaimer actually apply? And the courts found no, it didn't, because the term was only made aware to the person after they had entered the contract, right? And even then, they had to go somewhere else to look it up, so it wasn't even on the ticket that they saw. So for that reason, it wasn't part of the contract. Now things can get a little bit more subtle than that, and to do that I think we need to look at a third case. In the case of Balmain, New Ferry and Robertson, we have a customer, Robertson, wanting to catch the ferry into Sydney. So he goes to the jetty to catch the ferry, and you can imagine that we've got the turnstile, and he goes through the turnstile, is the first thing, and then he misses the ferry. He misses the ferry, and he goes to go back out. turnstile. Now, how do they actually charge for the ferry? Well, you had to pay 1 cent or one penny when you went in, and you wouldn't pay at the other end. And when you left here, when you came back from Sydney, you wouldn't pay it here because it's all very busy. You'd come back, and when you left, you'd pay the 1 cent or the penny when you left the wharf. So once he misses the ferry, he attempts to go out the turnstile, and the attendant wants to charge him another cent or another penny, and he objects to this because he's missed the ferry. Now, there is this notice in place that says a fare of 1 penny must be paid on entering or leaving the wharf. No exception will be made to this whether the passenger has travelled by ferry or not. And that notice is placed here. The notice is placed after you pay your penny and enter. So it becomes, is it a term of the contract? And the court found, actually, this is too late for this contract here because notice has occurred after the contract has been formed, after you've actually paid your penny. So this is not a reasonable notice. However, it's a big however, because Robertson had caught the ferry so many times, it was considered part or a term of the contract. And the reason for that was that Robertson could be deemed to be aware of the term, and it could be implied into the contract because he had caught the ferry so many times before and seen the notice so many times previously. So it was implied because of previous dealings. Okay, big thing for us. The notice after the contract's entered into was not reasonable notice, but you must be aware that your previous dealings might overcome that kind of situation. So if you've used a car park or you've used something several times before, it's likely the notice will be implied due to previous dealings, despite that notice not being reasonable notice each time every individual contract is actually entered into. As well as notice being given prior to entering into the contract, it must be reasonably obvious that the term is meant to be contractual and a term of the contract. And a case for this is Corser and Brown. It had to do with dry cleaning a dress. And as the dress goes in to be dry cleaned, they give you a ticket. And on the ticket, it actually said, no responsibility accepted for loss or injury caused to articles. Now the issue here is, was this a term of the contract or not? Because of course it's a court case, so the dress ended up being damaged. And the courts held, you know what, no, that wasn't a term of the contract. There was no reason for Corser to expect that it was anything other than a docket that they had to get the dress back. And so it wasn't brought to their notice, it wasn't seen as a part or a term of the contract, even though it occurred when the contract was formed. So for that reason, it wasn't deemed reasonable notice. So this leads to the interesting situation where we have, say, tickets like airline tickets or concert tickets that have terms as part of them. Generally, those will be considered terms of the contract. Now we can see some situations where that's been difficult, Le Mans, etc. But you generally see there people are being misdirected. Generally, when you buy a ticket and it has the terms and conditions on it, they are considered terms of the contract. You'll also notice that sometimes you can't fit them all on there. Big airline tickets and things like that, for instance. When that occurs, what you find is that they refer to something else, to another document. And in those instances, referring to the other document is sufficient to allow you to go and work out what the terms and conditions are before you contract or as you contract. And so in those instances, the courts will say, yeah, even if they're referring to something else, you will find that those terms and conditions do form part of the contract because you were given reasonable notice of them, that they existed, and it was up to you to go look at them at the time of the contract. And the case for that one is Thomson and London, Midland and Scottish Railway. So in Thomson and London, Midland and Scottish Railway Company, we have Ms. Thomson, who was catching a train. So we've got the railway over here. And as she goes to get off the train, it stops slightly past the platform, and as she steps off, she misses it, falls and injures herself. Then she's claiming compensation from the railway for the injury that she suffers. Now, London, Midland and Scottish Railway had set out a term of their contract that protected them from liability. That term was actually over here in their timetable, and the contract was the subject of this ticket, and the ticket referred to the terms of purchasing a ticket on the timetable. Mrs. Thomson actually argued that one, her daughter had bought the ticket, so she had no chance to actually look at the terms, and two, that in any sense she was illiterate, and so she wouldn't even be able to read those terms and conditions. And she was arguing, well, I didn't know about that term, so it shouldn't apply to me. What did the court decide here? And again, here we see some practical reality meeting the law. So it's always difficult around hard cases like this, but the courts do have to take practical reality into consideration. And you think about it, if you had to notify every train passenger of the key terms when you were doing it, just in case they were illiterate, etc., or just in case they weren't the person buying it, then you can imagine how that would clog up commerce. So what the court said here was, really, London, Midland and Scottish Railway, they've done everything that they reasonably could. Everything they reasonably could. Okay, they were notified at the time of the contract. Where the terms were held in the timetable was something that was readily available and that most people would have who regularly travelled on a train, or you could get easily at the time that you were contracting. So because of that, the railway had done everything they reasonably could to bring it to their attention, and so this actually was a term of the contract. So reasonable notice doesn't mean that the person had to have notice. We're really looking at doing everything you reasonably can in the situation to bring it to the attention of the contracting parties. Just to summarise, if we're going to have a term, it can be written in a written and signed document. It will nearly always be a term. There's some rare exceptions there. If it's not in a written signed document, then we must have reasonable notice. That notice must occur before the contract, right? And it must be fairly obvious that it's meant to be a term of the contract. Remember here that it's about the parties doing all that they reasonably can to bring it to notice, not that there actually was notice given, as that railway case we just went through showed. Now, on to the difference between terms and representations.